In a medical malpractice case in New York, can I subpoena the doctor's medical school grades to show that the doctor was not a good student in medical school? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, one of the things we want to try and accomplish is, what were the doctor's grades? How did he do in medical school? And now you may be thinking, oh wow, if the doctor was a terrible student, we can now use that at trial to show that he was horrible and didn't know what he was doing when he was treating me. Well, fast forward 25 years. Let's say, for example, the doctor has been in practice for 25 years and that he's licensed to practice medicine in New York and board certified in the specialty in which he practices. So now the question becomes, can we go back into his medical school grades, assuming that they're still available and somebody can find them more than 25 years earlier? Can we extract that information and now show to the jury that because the doctor failed a class in medical school, that automatically relates to the fact that he did not know what he was doing when he was treating you? You think that can happen? Well, we can try and do that, but the reality is, in all likelihood, the defense attorney is going to object vigorously that what occurred in medical school 25 years earlier is totally unrelated to what the claims are and what the defenses are in this particular case. In fact, they're going to argue that what occurred in medical school has absolutely nothing to do with what occurred here and the doctor's knowledge. You want to know why? Because the defense will clearly argue that not only did the doctor graduate successfully from medical school, but then he went ahead and participated in an approved residency training program here in New York, and then went ahead and took a very difficult board certification examination which tests the doctor's knowledge and experience based upon the specialty he's going into. In fact, board certification happens to be the highest level certification a doctor can achieve in his or her specialty. In all likelihood, the judge is going to agree with the defense attorney and recognize that that has absolutely nothing to do with what occurred in this particular matter. Now, let's say the doctor is only 1 year out of school. That may make a difference. There may be certain instances where we can make a compelling argument to the court that because of the doctor's inexperience, that there's also a suspicion, and we have evidence to indicate that the doctor did terrible in certain things in medical school. And now we want to try and use that information to show to the jury that the doctor's knowledge and understanding clearly fell below the standards of care. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process as we go to trial. You know, I realize you have questions or concerns about your own particular matter. Well, if your medical malpractice matter happened here in the state of New York and you're contemplating what to do, I encourage you to pick up the phone and call me. Why? Because I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.